Who is in court? Where?
Defendant.
What is this echo that I'm hearing?
It's not from the office court, it's the pastor that joined online.
Appearances.
May please be Lord.
Council called me this morning. That one guy who was
yes, please go ahead. Let me see your face. I can't see you. Hello, Mr. Lokoja. I can see your system, but I can't see you.
Someone like coming from somewhere.
I cannot see you. Please go ahead and announce your appearance.
Here or not, my Lord. Appearing with Idigbe for the applicant.
Any other appearance?
Yes, my Lord. We respect to this honorable court. My name is Oyetunji Ojuokaye, Acting Director of Ministry of Justice. My appearance for the defendants.
Can you hear me, please?
Yes, my lord.
Very well. The applicant on the 9th of September 22 took out an application for enforcement of his right vid originating motion against the respondents, praying to the court for the following reliefs. Does an order of this court declaring illegal, unlawful, null, void, and unconstitutional order as of the respondents that undermine the subsisting employment rights of the applicant with the respondents, same having not been or being determined by the laid down requirements of the public service rules on appointment and condition of service of the third and fourth respondent and a purported dismissal of civil or public servant. 2, an order of this honorable court declaring illegal, unlawful, null and void, and unconstitutional all that acts of the respondents that undermine the proprietary rights of the applicant to his salary and any other right relating to his movable allowances for 65 months as a subsisting lecturer in the employment of the respondents from April 2017, September 2022, and still counting, which thereto violates and are likely to further violate the proprietary rights, financial rights of the applicant to salaries and allowances and denial to freely access, collect, and make use of his legally earned wages to be wrongful, illegal, null, void, and devoid of constitutional principles against the rule of law. 3, an order of this court declaring illegal, arbitrary use of official powers, unconstitutional, null, void, and the act of the respondent arbitrary, willful, and careless refusal to pay the applicant his salary or salaries duly worked for, and legally earned salary without just cause and without fair hearing and fair trial, and thereto violate the fundamental rights of the applicant to already earned salaries and allowances since the period of April 2017 to September 2022 and still counting, thereby wrongfully deprive the applicant the economic value and usage of his salaries and allowances, and thereby cause the applicant an immeasurable financial loss, economic hardship, torture, trauma, and lack of funds to attend to his immediate financial needs. 4, an order declaring illegal, void, null, and unknown to law and lack of legal procedure and arbitrary use of official powers of the respondents without due regard to the rule of law and in violation of the applicant's fundamental right to livelihood, property, to compulsorily violates the fundamental rights of the applicant by the outright refusal to pay the salaries and allowances of the applicant from the period of April 2017 to September 2022, a period of 65 months, and still counting contrary to sections 33, 34, 36, 43, 44, 1 and 2, and 254C of the 1999 Constitution of Nigeria's amended scheme of service for staff of Polytechnic of the respondent, and Articles 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 15, and 17 of the African Charter on Human and People's Rights Ratification and Enforcement Act, Cap 10 Laws of the Federation 1995, and order of the court directing the respondent to the total sum of 7,075 kobo of scheme of service for staff of Polytechnic of the respondent, and Articles 2, 3, 4 of the African Charter on Human and People's Rights Ratification and Enforcement Act. 6, an order of court reinstating the applicant to his office and position as entitled staff as provided under regulations or scheme of service governing the council, the condition of service for the staff and members of the 3rd and 4th respondent. 7, an order of court directing the respondent, especially the 3rd and 4th respondent, not to illegal henceforth withhold the salary and allowances of the applicant save as provided under the regulations or scheme of service governing the council for the staff members of the 3rd and 4th respondent. 8, an order of court fundamental rights of the applicant, staff members of the 3rd and 4th respondent, an order of court declaring the actions of the respondent that willfully undermines the fundamental rights of the applicant by illegally withholding the outstanding salaries and allowances of the applicant for 65 months and still counting by the respondent from I will skip the remaining reliefs. It seems to be almost the same. The grounds upon which the application is brought are: 1, the applicant as citizen of protection of the relevant laws of this country in equal terms with everybody, no matter how high or low and whatsoever in the society. So I will skip all this. The applicant filed along with this application a 59-paragraph affidavit proposed to by himself and a written address, his argument in support. The respondent in opposition to the enforcement of fundamental right filed 24-paragraph counter affidavit deposed to by one Ejura Akpe. Those facts, and also accompanied it with written address. So I will now go straight to the.
Yeah, most of this will be asking on that is.
What is happening? What is happening? What is happening? It seems there's another sitting. And I'm hearing a council talking. I don't know what is going on.
Will be guided by the court.
Technical people.
The courtroom, please.
13th July.
Is it in the courtroom? It's not in the courtroom.
13th July is okay.
The technical team, please check your system. It seems that what is happening may possibly in another court is being echoed here. So I'll go straight to the decision of the court. It is pertinent for me at this stage to say that I will consider the objection raised in the process of the respondent as to the competence of this suit first. I will proceed to explain my reasons for adopting this procedure. This action was commenced under the Fundamental Human Rights Procedure by way of originating motion, hereinafter referred to as PREP. It is without doubt that the originating summons and originating motions are similar in nature in that they are both decided based on affidavit evidence. See the case of D Oil and Gas Limited versus SNG Limited citation captured. It is a law of commonplace that one of the objectives of originating summons or motion, as the case may be, is that proceedings initiated thereby very expeditiously dealt with. See the case of ETIM and PDP and other citation captured. Thus, it is clear that the procedure adopted in the two procedures are the same, and any procedure applicable in one will be applicable to the other. Courts have held that an originating summons and preliminary objection on jurisdiction can be taken together, provided the court determines the objection first before proceeding to address the merit of the case. See the cases of General Mohammed A. Garba retired and Mustafa Sani Mohammed and others citation captured, Yadua and others versus Yadoma and others citation captured, Dapia Long and others versus Dariye and another citation equally provided. In restating the principle of law, when a challenge to the jurisdiction of court is raised in an action commenced by originating summons, the Supreme Court per Mohammed JSC in the case of AG Lagos State and others versus AG of the Federation and others citation captured held, and I quote, when a preliminary objection is raised in an action such as the present one commenced by originating summons, it is always better to take the preliminary objection with a substantive case, that if the objection to the action succeeds, the case or action is terminated in limine. If the objection fails, however, then the court will proceed to determine the substantive action on its merit, unquote. Although the objection was not contained in the preliminary objection, but in the counter affidavit in opposition to the affidavit in support of the originating motion, and also in the written address in support, the court will still consider the objection first before it even considers the merits of the substantive action, as I've stated earlier. In addressing the said objection to the competence of the suit, I will take the objection respecting the limitation law first, because it is only where the right of action has not been extinguished by a statute of limitation that this court will be competent to even look at other issues relating to the mode of commencement. It is the contention of learned respondents counsel, via their counter affidavit and written address, that the applicant, being a public servant, has only 3 months within which to initiate the suit against the defendants who are public officers, that the cause of action arose since 2015 and was instituted outside the 3 months as required by Section 3 of Public Officers Protection Act, hereinafter referred to as POPA. It is the argument of counsel that the applicant has slept over his right. Learned applicant's counsel reaction to this is that fundamental right actions are not affected by limitation period, as well as action emanating from malice, abuse of power, arbitrary use of powers, illegal action of an official, and or wrongful withholding of salary do not enjoy the protection of limitation law. The objection raised by learned respondent counsel, Joe Kaya Esquire, no doubt goes to the very root of this matter, which borders on the competence of this court to adjudicate on this suit. The law is well established that once an issue of jurisdiction is raised by either party in an action, it must be considered first. This is because jurisdiction poses crucial question of competence. See the case of Oni and Calgary Nigeria PLC citation provided. Jurisdiction is the very basis on which any court tries a case. Being the lifeline of all trials, a trial without jurisdiction is a nullity. See the case of Uwamu and Uwamu citation captured, the case of Dada and Federal Republic of Nigeria citation provided, Adegbola and Usiyi citation provided. Now to the heart of the issue raised by the defendants on whether or not this action is statute bad. The law is right that once an action is challenged on the basis that it is statute bad, it follows that the court's jurisdiction is questioned. See the case of Rescue Construction Company Limited and another versus Adeshola and others. It is germane to emphasize at this point that a cause of action is statute bad if legal proceedings cannot be commenced because the period laid down in the statute of limitation has elapsed. Therefore, where an action is statute bad, a claimant who might have had cause of action loses the right to enforce that cause of complaint by judicial process because the period of time laid down by the limitation law for initiating such an action has elapsed. See the case of Enugu State Civil Service Commission and others versus Godfrey citation provided. This is because the legal right to enforce an action is not a perpetual right, but a right generally limited by law. The court, in order to determine whether or not an action is statute bad, must do so by taking a look at the writ of summons and statement of claim, alleging when the wrong was committed, which gave rise to the cause of action, and by comparing the date on which the action was filed. See the case of Military Administrator, Ekiti State, and Aladeyelu, citation provided. For the purpose of emphasis, it needs to be stated that time will begin to run when the cause of action accrues. See the case of Hombi and Attorney General Benue State, citation provided. The case of NIIA versus Anyafalu, citation also provided. Accrual of cause of action is a time when the act which gave rise to the suit has been completed, and the applicant is aware in such a way that the claimant can begin to maintain an action against the defendant. It is clear from the processes filed by the applicant before this court that his salary was stopped in 2017. The appropriate question requiring an answer is that the applicant's cause of action arose in April 2017 when his salary was stopped. A public officer can avail himself of the protection afforded by Section 2 of the Public Officers Protection Act while discharging his duties. As such, if the action against him is not instituted within 3 months next after the act, neglect or default complaint of, or in the case of continuing damage or injury within 3 months next after the easing thereof. In the instant case, the applicant is challenging the stoppage of his salary without any formal letter, is engaging him from the employment of the respondent. It is deducible from the facts deposed to by the applicant that the cause of action arose in 2017 when the salary was stopped, though there was no specific date in his affidavit. However, the applicant's action was instituted on 9 September 2022, which is about 5 years if my knowledge of mathematics does not fail me. Section 254C1D of the Constitution of the Federal Republic of Nigeria, hereafter referred to as the Constitution, empowers this court to the exclusion of any court in matters relating to or connected with any dispute over the interpretation and application of a provision of Chapter 4 of the same Constitution as it relates to any employment, labor, industrial relations, trade unionism, employers association, or any other matter which the court has jurisdiction to hear and determine. By Order 3, Rule 1C of the Rules of this Court, 2017, an action may be commenced by originating motion. Equally, by Order 3, Rule 1, Paragraph G of the same Rules of Civil Procedure Rules of this Court, an action can be commenced by any other means that may be prescribed by these rules, act or law in force in Nigeria. Applicant instituted this action as stated severally by way of originating motion under the FREP 2009, which qualifies as a law in force under Order 3, Rule 1C of NIC rules. By the provisions of Order 3 of the FREP, It provides that, just a minute. It provides that an application for the enforcement of fundamental rights under the rules shall not be affected by any limitation statute whatsoever. Interestingly, the Apex Court in the case of Mwanzi, an NRC citation provided, also recognized this when Ogumiju JSC, while delivering lead judgment, held us, and I quote, "The relevant issue in this case are similar to the issue in Lafia local government and Governor Nasarawa Supra. The suit had been commenced by way of fundamental rights procedure rules. This court applied the provisions of the Public Officers Protection Act to hold that that was not statute bad, being filed within the 3 months when the cause of action arose. It was the lesser period of limitation to the period provided by the fundamental rights enforcement rules. In this case, it is to be noted that by Order 3 of the Fundamental Rights Enforcement Procedure Rules 2009, no application for the enforcement of fundamental rights shall be affected by any limitation statute whatsoever. Unfortunately, the appellant's cause of action accrued in 1994, before the 2009 rules came into effect. My lords, the courts cannot extend the time for the commencement of the suit where same is caught by any statute of limitation. Cited in the quotation are Ugu and Suzwan, the case of Soil Grave Holdings Incorporated and Federal Government of Nigeria, unquote. It is clear from the above decision of the Apex Court that the court recognized the existence of such exemption clause in FREB, but only refused to apply it because the action accrued before the coming into effect of the FREB rules, which means that the position of the court will have been different if the action was instituted after 2009 the FREB rules came into effect. In this present, the claimant's cause of action accrued in 2017, which is after the coming into force of FREB rules. One may want to argue that the FREB rules does not apply to this court because the NIC was not mentioned or contemplated as one of the court referred to under the said rules. First, let me say that the said rules was made pre-Third Alteration Act 2010, which recognizes court as a superior court of record. Admittedly, FREB rules, which was made by the Chief Justice of Nigeria pursuant to Section 46(3) of the Constitution by Order 1, Rule 2, states that court means the Federal High Court or the High Court of the State or the High Court of the Federal Capital Territory, Abuja, which were obviously the court with civil jurisdiction then in respect of the fundamental human rights. This court, after the promulgation of FREB rules, was recognized by Section 6 of the Constitution as a superior court of record as stated supra. By the provision of Section 254C1, paragraph D, this court was given jurisdiction in respect of Chapter 4 of the Constitution as relates to employment. Section 46, pursuant to which FREB rules was made, gives a person power to apply to a high court of the state or FCT to seek redress. However, by Section 254D1 of the Constitution, which provides that for the purpose of exercising any jurisdiction conferred upon it by the Constitution or as may be conferred by an act of the National Assembly, the National Industrial Court shall have all the powers of a high court. Section 315 of the Constitution provides that existing law shall have effect with such modification as may be necessary to bring it in conformity with the provisions of the Constitution. By the provisions of Section 3154, Section 315, subsection 4, paragraph B of the Constitution, and existing law includes any rule of law or any enactment or instrument, and which FREB qualifies as one. By the combined effect of Sections 46, 254C1D, 254D1, and 315, subsection 1 and 4, and paragraph B of the Constitution, Order 1, Rule 2 of FREB rules, the rule is made applicable to this court. I've held supra that no period of limitation is applicable to any action instituted under the FREB rules. This is obviously because of their special nature. I've also held that the FREB rules applies in this court, the effect of which is that the provision of Order 3 therein will also apply in this court. Accordingly, the period of limitation in Section 3 of POPA will no doubt not apply. Assuming though not conceded that the period of limitation in Section 3 of POPA will even apply in this case, it must be noted that the said limitation period by virtue of Section 2 will begin to run within 3 months of the act complained of, or in case of continuing injury or damage within 3 months from the season thereof. See the case of Mobile Producing Unlimited and Davidson, citation captured, AG River State and AG Bayelsa State, citation captured. The act complained of in this case, which is the stoppage of applicant's salary without issuance of a letter of dismissal, is still continuing till date. Applicant's salary was still not being paid, and he has equally not been issued with any letter of dismissal till the institution of this action. Thus, the act or neglect of the respondent complained of has still not ceased, as it is still continuing because claimant's salary has still remained unpaid, and he has equally not been issued with a letter disengaging him from the services of the defendants. Accordingly, the period of limitation in POPA has not started running, as the act complained of has not ceased. In view of all reasons supra, I am of the considered view that applicant's action is not statute barred. Now, let me address the second issue as it relates to the mode of commencement of this action. The jurisdiction of a court must be invoked before a court can be said to be competent to entertain an action, and to determine this, the court must satisfy itself as to the following: that A, it is properly constituted in terms of number and qualification of its members. B, the subject matter of the action must be within the jurisdiction of the court in the sense that it has competent to adjudicate over it. And most importantly, in this case, C, the matter is initiated by due process of law with nothing to rob the court of its jurisdiction. See the notorious case of Madukoli and Kemdili, citation captured. The contention of parties relates to whether or not the jurisdiction of the court has been properly invoked by the mode of commencement of this action. As stated severally in this case, claimant instituted this action by way of fundamental rights enforcement under the FREB rules. The Apex Court in the case of Mwanze and NLC Supra, specifically at pages 293 to 294, paragraphs E to E, at page 296, paragraph B to D, held that when an application was brought under the 79 FREB, a condition precedent to the exercise of the court's jurisdiction was that the enforcement of the fundamental right or securing enforcement thereof should be the main or principal claim and not an accessory claim. Therefore, where the main claim is not for the enforcement of fundamental rights or securing the enforcement of fundamental rights, the jurisdiction cannot be properly exercised, as it will be incompetent. The court held that the appellant's alleged breach of fundamental right arose from the termination of his employment. In the same vein, the Court of Appeal, in the case of Briggs and Harry, citation captured, held that for an applicant to successfully institute an action under FREB rules, the claim must fall within sections 33 to 44 of the Constitution, and the court has to determine this by considering not only the affidavit, but also the relief sought to see, if it could be seen, said that the breach of such fundamental human right was the main claim in the action. The court held that the order the appellant therein was seeking was glaring, that reinstating him to his post, which signifies that the fulcrum of his action was wrongful termination by failure of the employer to adhere to basic principles of natural justice. That the alleged breach of appellant's right to fair hearing flowed directly from his substantive allegation of termination of his employment without being invited. The court went further at page 75, paragraph E to F, that employment issues are not fundamental rights, so they cannot be claimed under the FREB rules. The above case is similar in some respect to the case at hand. The applicant in the instant action is by way of his relief seeking an order of this court declaring his purported dismissal without a letter of dismissal unlawful, and a consequential order restoring his salaries, which signifies the fulcrum of his action, which was on employment. The applicant's allegation that his right to fair hearing, fair trial has been breached flows directly from his allegation that his salary was arbitrarily stopped and purportedly dismissed unlawfully without any letter of dismissal. His main claim is not for the enforcement of his fundamental rights. The alleged breach of his fundamental right is so inextricably linked to the alleged unlawful stoppage of salary and unlawful purported dismissal. In my humble view, applicant could not have validly brought this action by way of enforcement of fundamental right, since his main claim in this action was for restoration of his employment and salary. In my view, he has not sufficiently invoked the jurisdiction of this court by way of due process because of the mode of commencement of this action. Now, assuming the applicant has sufficiently invoked the jurisdiction of this court by the mode he used in commencing the suit, which I'm not conceding, I've carefully read the affidavit in support of the originating motion, further affidavit and counter affidavit, and I'm of the firm view that the respondent allegation of non-clearance of the appellant, as well as other irreconcilable conflict, will not make originating motion the proper mode for the determination of this action. Order 3, Rule 2, sub-paragraph B of the rules of this court provides that where any matter relating to Section 254CD of the Constitution is to be filed before the court, such a matter, if it relates to interpretation and application, shall be by way of complaint. Surely, any attempt to prove the liability of the respondent through originating motion procedure, where affidavit and counter affidavit and vain subsistence of substantial disputes must be resisted by the court. It cannot be otherwise, for substantial dispute could only be resolved in the usual adversarial proceedings upon the settlement and exchange of pleadings. Averment in pleadings borne out by oral evidence tested in cross-examination. See the case of Cameroon Airlines and Ututu Izu citation captured the notorious case of Udutola and Paper Sack Nigeria Limited citation provided. To my mind, that approach was a sacrilegious affront to a basic requirement that a person who is so confronted should be able to confront his accuser. This is usually done through cross-examination or by the confrontation or contradiction of all the witnesses that testify against him. See the case of Daudu and MPC citation provided. Again, with the allegation that the applicant was not cleared by the staff screening committee, coupled with other irreconcilable conflicts in the affidavit, counter affidavit, and further affidavit filed by the parties, it becomes crystal clear that there is palpable dispute on the facts which make the proceedings hostile or contentious and unsuitable for adjudication under the originating motion as we have under fundamental human rights application. See the case of Ekanem and others as registered trustees of the Church of Christ, the God Shepherd and others, unreported case, appeal number SC/349/2011, judgment was delivered on 2nd of December 2022. I bear in mind that it is not all disputes that will be material to call oral evidence. However, disputes between parties in this case are so material that they go to the root of the case at hand, which in my view cannot be resolved by affidavit evidence. The point must be made that facts are the springboard of law, as it is facts that would determine the appropriate procedure to be adopted in instituting an action. The facts of this case clearly show that the dispute cannot be resolved on affidavit evidence, as there would be need to call oral evidence. This is because facts are most times inconsequential or play infinitesimal roles in suit commenced by either originating motion or originating summons, as they are basically for review of administrative powers or orders and interpretation of documents, unlike the general form of complaint procedure, where facts are the bedrock of the action. The applicant's allegation that he was not invited before any panel or indicted before the stoppage of his salary and his allegation of purported dismissal are all allegations of facts that must be tested under the fire of cross-examination. It is thus improper for him to have commenced this action by way of originating motion, especially in this case, where facts are contentious as seen in the several affidavits filed by each of the parties. Just recently, the Apex Court in the majority decision in the case of APC versus Bashir Sharif and two others on reported appeal number SC versus CV, /CV/1689/2021, a judgment delivered on the 6th of February 2023 held that failure of the respondent in the action to commence its that the failure of the respondent in that action to commence that suit, which was contentious to institute that action by way of writ of summons, was fatal, and his action liable to be set aside because the procedure adopted to ventilate grievances is wrong and the process ought to be struck out. In view of all the reasoning supra, this court finds that it cannot successfully determine the action by way of enforcement of fundamental right. It is for this reason, and as stated earlier in this judgment, that I will not go into the merits of the originating motion. Ordinarily, the proper order to be made at this stage is an order striking out the action. However, this court, in the exercise of its discretion, thinks it expedient that it is far better to order that parties convert the originating process, which is the originating motion, to a general form of complaint to enable this court consider the merits of the case between parties in the spirit of doing substantial justice and fair trial. See the case of Akero Doro and Abraham and others citation provided, the case of Ogli Oko Memorial Farm Limited and another versus Nigerian Agri Cooperative Bank Limited citation provided. Consequently, I therefore make consequential order that the originating process should be converted to general form of complaint to allow the court to consider the substance of the main suit and to enable parties to file pleadings. Accordingly, the claimant is given 7 days to file his pleadings, and advance copies served on the defendant, who is to also file its defense or their defense equally within 7 days. I so order.
I was good from your Lord.
Ruling is entered.
Thank you.
We are most grateful to your Lordship for your kind considerations.
Very well. Call the next case.
Case number 2, NICM LKJ 16M 2021 between Mr. Ocholi Sunday Matthew and 1 Kogi State College of Education, Ampa. 2, the registrar, Kogi State College of Education, Ampa. 3, J.A. Akuma, Principal Executive Officer. 2, 4, the Chairman, Kogi State Pension Board, Lokoja, Kogi State. Parties are absent.
Parties absent. Appearances.
We profound humility and respect to my noble Lord. F.Y. Ibrahim, my most humble appearance is for the judgment creditor.
Sorry, I can't hear you.
F.Y.
I
Ibrahim.
can't hear you well.
F.Y. Ibrahim. Ibrahim.
Okay. For who? Who are you representing for?
Judgment creditor applicant.
For the judgment creditor applicant.
Yes, my Lord.
Any other appearance?
May it please this honorable court. My name is Oluwafemi O Idigbe. State legal advisor. I appear with my learned friends, V.A. Shaibu, legal officer, and Victor Atta, legal officer. We announce our appearance for the judgment debtors respondents.
This matter was adjourned sine die to enable the appeal proceed. So
Yes,
why
my
are
lord.
you here?
My lord, we're surprised. We didn't even get hearing notice for today's proceedings. We are in another matter, and then we stumbled on the name on the case on the cost list.
Cost list.
Yes, my lord.
Mr. Ibrahim, why are you here? Mr. Ibrahim, are you here? Are you hearing me?
Okay. Yes, my lord.
Mr. Ibrahim.
Yes, my lord.
Why are you back?
We have a movement expertise wherein we seek the order
What
of
has
this
happened to the matter of the Court of Appeal?
It is still ongoing. It has not been determined. It has not been determined.
And so why are you here if the case at the Court of Appeal has not been determined? And the basis for which this matter was adjourned sine die is to allow the Court of Appeal deal with it.
Sorry, my lord. The information we got from the council that appeared last is different from the information I'm getting from the court now.
What was the information you got?
Yes, we have a motion on notice dated 11th day of January 2023, filed on the 17th day. We thought that was a motion that was supposed to be heard on the last adjourned date. But the court was unable to hear the motion, so the matter was because our counsel came late to court.
You filed a motion on notice when?
Dated,
Mr. Ibrahim, you said of appeal.
Dated the 10th day of
Did you file
January
it here or at the Court of Appeal?
Sorry, my lord. Before this court.
Mr. Ibrahim.
Yes, my lord.
What I can see that you filed was a motion experte on the 20th of April. That's the only one that is on, yes, in the case file here. That's the only.
Before then, we had filed another motion. It's dated the 10th day of.
What was the purpose? What was the purpose of that motion?
That motion was for a committal.
Okay, Mr. Ibrahim, I've earlier asked a question, and I want to repeat that question. Has the Court of Appeal decided the matter, the appeal before the court?
No, my lord.
And so why are you here? I don't have jurisdiction on any of these issues here anymore until the Court of Appeal has decided on it.
As the court pleases.
And depending on where the justice of the case tilts, that is when you may decide to come back.
We take the hint of the court. We are very sorry. It was a mistake on our part. The counsel that came on the last day did not inform us properly.
Case at Johnson and Dyer.
As the court pleases.
For the next case. A motion struck out. Motion expert struck out.
Case number 3, NICM LKJ 017. Haji Ali Haba Obolja. 3, Musa Baba Moses. 4, Ali Joseph. 5, Haji Musa Muhammad, and 10 others. My Lord, the first and tenants are also absent.
Who is in court?
First and third claimants.
First and third claimants. First and third claimants are in court. Who is absent? Unmute your phone, court registrar.
First and third claimants are in court, others absent. Defendants are also absent.
Appearances.
Please. I am I.O. Ali.
You are who?
I.O. Ali.
I.O. Aliyu.
Yes, my Lord.
Very well. You are for who?
My Lord, I am for the claimants. And there with me, my Lord, is my dear brother, U.F. Musa. U.F. Musa.
BM or BF?
U.F. U.F.
UF.
U.F.
Very well.
U.F. Musa.
Very well.
All the claimants.
Any other appearance? Any other appearance? Any other appearance?
From the open court, my Lord.
Any other appearance online? Mr. Ibrahim, what's the business of the day? It's adoption of...
Yes, Lord. On the last day, my Lord ordered that whether this case has to do the procedure of part 1 of the TBA. And the Lord,
so have you filed?
Yes, we have filed our address and our payment that of the defendant, but we both filed out of time. We have motions regularizing the Lord. We have motions to bring in our processes.
When did you file the motion?
Oh, Lord, we filed the motion. The motion is dated on 15. We filed the same date. Dated on 15th day of May 2023.
May 15th.
Sorry, Lord. We filed. It's filed on 19th of May.
You filed when?
Day of May 2023. 19th day of May of payment. 19th day of May 2023, Lord. 19th day of May 2023. We filed the motion and the process, the address on issue raised so moved.
Okay. You filed on 19th.
Yes, Lord. We filed our address on 19th with a motion to bring it within time on 19th day of May.
Yes, I'm talking about the motion.
Yes, Lord.
So you filed the motion also on the 19th.
Yes, Lord.
And the claimant is not here. Defense counsel.
Defense counsel, we have exchanged. Yesterday we spoke. I told you we'll be online.
What's his name? What is his name?
His name is sorry, Lord. Man
Tule Shuaibu.
Sule Shuaibu, Esquire.
Mr. Shuaibu, I can see VA Shuaibu Esquire. Unmute your phone. If it's the same Shuaibu, unmute your phone. I have VA Shuaibu. If you are the same Shuaibu, unmute your phone because you are muted. If you can hear me, unmute it so that I can hear you and I can talk to you. Is it the same Shuaibu? Eh?
It's not the same.
Oh, it's not the same. Okay. So the defense counsel is not here. So, Mr. Ali, what do you want the court to do?
Okay, I'm representing.
Let me see.
Yes.
Who is addressing the court?
We want to move our motion for the extension of time to enable us to adopt our address.
Have you served the process on the defendant?
Yes, my Lord. We have served both the motion and the address on the defendant. And I also
They
sent
also
him
filed their own address.
Yes, he sent me a copy to show that he filed. He sent me a soft copy showing that he filed both a motion and his own address too. He filed and he served me the copy, soft copy. Lord.
When did he file? He filed on the 23rd May.
On Wednesday, Lord. Yes, I think the day before yesterday or so.
He filed on 23rd. Very well.
That's complete.
So go ahead and move your application.
Well, I agree with me, Lord. My Lord, the application is dated the 15th day of May 2023. It is brought. The application is dated the 15th day of May 2023, and it is brought pursuant to Order 17, Rule 1, Rule 4 and 9, and Order 57, Rule 4, Sub 1 of the rules of this Honorable Court, Lord. Lord is seeking for orders for extension of time, within which the claimant can bring his address. The time ordered by my Lord haven't lapsed.
Order as prayed.
As copy.
Order as prayed.
You are great to me, Lord. Very great to me, Lord.
Very well.
Yes, my Lord.
So go ahead and adopt your address.
You are great to me, Lord. Lord, we have filed our address on 19th of May 2023. And it is dated the 15th day of May 2023, Lord.
Go ahead.
Issues. And we argue them simultaneously, Lord. We adopt same as our address on the issue raised by my noble Lord, so much to the Lord. My Lord, we see on the address, and we all agree that the claimant's case is not such that is to pass through the procedures of the Trade Disputes Act, as has been decided in two cases that were cited in law. In this address, the first case we cited is a persuasive one. It's a decision of this court, but it has been given an authority confirmation by the Court of Appeal in another case we cited again in this address. RTN and others versus Ajiwale and others, 2016. LPELR 41271, particularly at page 2, a Court of Appeal decision. We commend that authority on my lord and urge my lord to agree to our submission. As my lord we read, we will not intend to bug my lord to make extra submission orally. My lord we read the authority and see that my lord will be right in holding our submission in line with this case of the Court of Appeal, as it is on all four with the situation of the issue raised in the circumstance of the claimant's case. We commend that authority on your noble lordship. We urge your lordship to read that authority as it addressed the issue raised so much by my noble lord. That is our submission, Lord. We are very grateful, Lord.
Yes, my lord. My lord. My lord. My lord, I'm online for the first to 9 defendants. My lord. My lord. My lord. I'm online for the first to 9 defendants, my lord. My lord.
Hold on, please.
I'm online for the first to 9 defendants.
Hold on, my lord can hear you. Just hold on.
Okay.
Like 21st century one. If you want to talk, you talk here.
Yes, my. May this honorable copy, please. I leave Al-Hassan on the line, my lord.
Hold on, please. My lord, the network has gone off. The system has gone off. Just hold on.
Okay. Once she return, let her know, because I've not even announced her appearance.
We couldn't hear you. So just hold on. When
I'll be
when
sure to
it's
see
back,
It's
so.
because you muted yourself.
yeah. So when she comes, you unmute yourself and you speak. And when you are done speaking, you mute again. Yeah.
And the registrar was sending message. You didn't check the chat. I said I'm for sort of to have drawn the attention of my lord too.
Calm down now. We are listening to you. Wait. Yeah, I don't want to. Wait, they come.
Learned Council, apologies, my internet had issues. So I had to pick up another one and was trying to check the data on the other Wi-Fi. So I just got it right. Mr. Aliyu,
Yes,
what
Lord.
do you want me to do to the process filed by the defense?
The defense online. We have been struggling to talk to court, my Lord.
First, yes, my Lord. We have a motion of notice. We
Is
have
that
motion of
Mr.
notice, my Lord.
Is that Mr. Aliyu who is addressing the court?
Sorry, my Lord. Is the counsel to the defendant? He said he has been
Oh, you are
struggling.
just here now. Okay.
Yes.
What's your name?
Ali Hassan is my name, my Lord. Aliyu Al Hassan.
Aliyu Al Hassan. Counsel
Yes,
for
my
the
Lord.
claimant is I.O. Aliyu.
Yes, my Lord.
And you are Aliyu Al Hassan.
Yes, my Lord. My appearance is the first to 9 defendant. For the first to 9th defendant.
Very well. So you said you filed what?
Yes. We have motion on notice.
When was it filed?
32nd. It was filed on 23rd of this month.
Mm-hmm.
Yes, my Lord, is a motion for extension of time to file our address as ordered by the court.
Very well. Mr. Aliyu Esquire, claimant counsel, any objection to it?
No, my Lord, there can't be objection.
Move in terms.
Okay, we move in terms of motion paper, my Lord.
Order is as prayed.
Yes, as called, please, my Lord. My Lord, in compliance with the order of this honorable court, we also will file our written address.
Mm-hmm.
It was filed on 23rd day of May 2023. My Lord, we allow us to contain a written address. Can you hear me, my Lord?
Mr. Aliyu,
Yes, my lord.
you filed
A written address dated 22nd day of May, 2023.
Okay.
And it was filed on 23rd day of May, 2023.
Yes.
My lord, we seek to adopt our written address.
Are you in the same chambers with Sule Shuaibu? Mr. Ali Hassan?
Yes, my lord.
Because your name is not on the list of lawyers in that chambers. So are you holding brief?
Yes, I'm very sorry, my lord. I'm holding brief of Sule Shuaibu. That's right. Yes, my lord. We adopt our written address. With the leave of this honorable, can I hold this honorable God to strike out this matter for being premature?
Very well. Let me have the diary. Did you file any reaction, any reply, Mr. Liu?
No reply.
There was no need for reply as they. There was no need for reply as my lord is free. The authority is not for that we cited. No reply.
This matter will fall into the vacation period.
Scott, please. I don't say it will fall into that.
So we have to move it to October for ruling.
Sorry, I cannot hear the date, Milord.
I said it has to be moved to October for ruling.
Okay.
October for ruling. No particular date yet.
October 12th.
Pardon, Milord. Sorry, Milord.
12th of
Okay, Milord.
October.
Ascot, please, Milord. Ascot.
It's convenient for me.
Please, my lord. Ascot, please. We have most great.
It's convenient.
It's adjourned by consent of council to 12/10/2023 for ruling.
Ascot, please. We are most grateful, my lord.
Call the next case.
I wish my lord a peaceful vacation.
Thank you.
Ascot, please.
Number 4, NICN LKJ 0 between Honorable Funsho Emmanuel Olorunfemi and 5 others, and 1 Kababunu Local Government, 2 Ministry of Local Government and Chieftaincy Affairs. Parties are absent.
Appearances.
Very pleased, my lord. I am T.F. Kolawole. Appearing with me, my lord, is my learned colleague, Arafat Muazu.
You are for who?
We are for the claimant, my lord.
Arafat.
Arafat Muazu.
Very well. Any other appearance?
Yes, my lord.
Mm-hmm.
Yes, my lord. Yes, my lord.
Go ahead.
I see due.
For?
My appearance is for the defendant.
Very well. Mm-hmm.
Yes, my lord. The defendant have a motion on notice, and I don't know if they are ready to move them.
Defendant.
Yes, my lord.
Are you ready to move your application?
Yes, my lord.
Any objection, Mr. Kolawole Esquire?
No, my lord.
Move in terms.
My lord, this is a motion on notice brought pursuant to Order 17, Rules 1. And
when was it filed?
It was filed on the 10th of February, 2023.
Very well.
And dated 26th January, 2023.
Order is as prayed.
Let's go to my lord.
Mm-hmm. Any other thing?
My lord, I'll be asking for a date for reply on point of law.
Reply on point of law or reply to the defense.
Reply to the joint statement of defense filed by the defendant.
Very well. So it's not a reply on point of law. And you have to equally file the witness statement to talk to that reply to the defense. What date?
17th July.
Is it convenient?
It's convenient, my lord.
Yes, my lord.
th of July.
As God pleases.
Can you hear me, please? Can you hear me?
Yes, my lord.
Court registrar.
Yes, my lord. Can hear.
Can you hear me?
Yes, my lord.
Luke Esquire, can you hear me?
Yes, my lord.
Can you hear me, please?
Yes, my lord.
Court
Lord, we can hear you.
Okay. The matter is adjourned to 17th of July 23 for definite hearing.
As a court, please.
So call
Yeah, most grateful.
Most grateful.
call the next case. Very well.
Test number 5.
Go ahead.
NICN LKJ 09-2022 between Arewa Adejo A and 156 others, and 1 Federal Polytechnic, either 2 Governing Council, Federal Polytechnic, either 3 Federal Ministry of Education, Abuja. My lord, payment number 57.
Go ahead.
And 138 and 4 others absent.
Appearances. I mean, defendant.
Absent, my lord.
Sorry, just a minute. Any representative of it? Appearances.
May please, my lord. My name is Austin Oboni.
Yes.
Probably will not appear for all the claimants.
I can see you. I cannot.
Let me raise my hand.
The claimants, Mr. Oboni.
Yes, my lord.
Any other appearance?
With the greatest respect, my lord, I most humbly appear for the first and second defendants. I am PC Obase.
Any other appearance?
My lord, I said, I most humbly appear for the first and second defendants. I am PC Obase.
First and second defendants.
Yes, my lord.
So, Mr. Obasi.
My Lord. My Lord, can you hear me, my Lord?
Yes. So are you ready to enter into your defense?
My Lord, we cannot hear you, sir. Please check, are you ready to enter your defense? Something like that.
Adoption. He has a motion. He just adopt. I mean 18th, not 17th. 17th, I'll be in Abuja. Help me. July. You don't have it. So that's 17. I have 3 cases in the National Industrial Court of William. That's, you know, I told you yesterday. That's 17th. It's 18th that I am here. Yeah. Give us after vacation. What time now? Give us, suggest now. Let's look at our after vacation. Off. Yeah. Okay. Oh, okay now. Yeah, do this.
Obasi.
Lord.
Yes, I was asking that, are you ready to open your matter?
My Lord, the matter is adjourned today for continuation of hearing. After taking the claimant's sole witness on the last adjournment, he took a date for, he said he wanted to call more witnesses.
Mr. Oboni. Mr. Oboni.
Okay.
Yes, my Lord.
Who do you want to call?
My Lord, we have a motion.
When did you file the motion?
On the 16th day of May.
You want to amend your originating process?
Yes, my Lord.
Mr. Obasi, are you in receipt of the application?
My Lord, I am not in physical receipt of the application. But however, the counsel that filed this suit, Ibrahim, he informed me through a phone call that he served the motion directly on the first defendant. They've not transmitted it to me, although the time waiting to respond to the motion is still running. Even on the date, he said he served the first defendant.
When did they file the first defendant?
When he served
the first defendant.
The day he called on phone and then they served his about 6 days ago.
My Lord, sir.
The motion was filed on, is it 18th or 16th?
On the 16th, my Lord, the defendant was served on the 17th. The counsel here was called and was told, we want to serve you a process. And he said, go and serve the poly. And they served the poly on the 17th. And they told him, we have served the poly on that same day.
Well, what I want to know is whether or not he's objecting to the application.
We would have just
Mr.
gone through the application, the one I took from him in the courtroom, and found out that the application which we will object to. The time within which we file the objection is still running. I will want to invest the remaining.
If you were indeed served on the 17th, today is 25th.
Yes, my Lord, it's still running.
So you're out of time. You have 7 days.
Yes, my Lord, the 7 days will start running on 18th. Because
Mr. Oboni.
Yes, my Lord.
When did you say you served them?
On the 17th day of May, 2023.
So calculate from 17th.
Today is the 8th day.
Date.
No, my Lord, we still have to confirm that it is served on 17th. There is no proof of that. We will try to. But from my own calculation from the date.
What registrar, do you have a proof of service?
My lord.
Court registrar. Court registrar. You have the proof of service.
My lord, I don't have it here with me, except if it's attached to that original, my lord.
Proof of service.
Because what I have here is that I, Austin Oboni Esquire, counsel to the claimant, applicant, do undertake
Service, and he has
to
not
serve
brought
the
proof of service to us.
yes,
Just
to
saying
the
it.
first
He
and
has not
second
brought it.
defendant. So there is no proof here if you undertook to serve, and you signed that on the 17th, not even on the day you file the process. So
Yes,
if you signed that on the 17th, then you wouldn't have served on the same 17th. And if you did, there's no proof.
As a please, but
So
we served
Mr.
on the
Bassi,
17th.
you're right. Well, I don't have that.
My lord,
So
he
let's
hasn't
take
brought
another
proof
date.
of service to us.
Yes, very well.
No, sir,
So
for the
take
hearing
another
of-
date. The
for
motion
the
is not
hearing-
right.
For the hearing of the motion, sir, if we may ask for a date in June, sir. Those,
Court registrar, is that date convenient?
17th
Any
July, my
date in
lord.
June?
No, the data is not there.
just for the motion.
No date.
17th, I'm in Abuja.
No date in June.
No, my lord.
So what date?
Give us an 18th. 18th is for adoption.
So what date?
18th.
Is it convenient to Boni Esquire?
Very well, Lord, it's convenient, sir. We agree.
By consent of counsel, the defense counsel is to file any reaction to the motion, if any, and serve an advance copy on the defense claimants. By consent of counsel, case adjourned to 18/7/2023 for hearing of motion.
Ask all please. You are most grateful, my lord.
Call the next case.
Case number 6. NICN LKJ 04/2022 between one Simeon Achenyo Joshua, 2 Umoru Useni, 3 Yusuf Azaya Idu, 4 Aturuku M Ocholi, and 1 Kogi State Government, 2 Attorney General and Commissioner for Justice, Kogi State, 3 Omala Local Government. My lord, first and fourth claimants are in court, others absent. Defendants are also absent.
Appearances.
Yes, please, my lord. I am A. Onoja, appearing with A. Ajiboye for the claimants. Who is this BH?
Any other appearance? Any appearance for the defense?
Me from the open court, my lord.
Any appearance online for the defense? Any appearance online for the defense? Nil for the defense. Mr. Noja, who is the defense counsel?
Idigbe, my lord.
She's online.
Mr. Adegboyega, your case has been called.
My name is Oluwafemi O. Adegboyega. State legal advisor. I appear with my learned friends, Victor Atta, Esquire, legal officer, and V.A. Shaibu.
Where are they? Where is Victor?
My lord, there.
Your line, sir.
My lord, and V.A. Shaibu.
Victor, what first?
Victor Atta.
Atta.
Legal officer. Yes, my lord. And V.A. Shaibu.
Okay.
Legal officer also. My lord, we appear for the defendants in this matter.
Very well. The matter is for definite hearing. Have you filed your defense?
My lord, the matter is for cross-examination, my lord.
But have you filed your defense?
My lord, we have not filed, but we intend to file tomorrow. We had a delay with our witness, who is supposed to come and endorse the witness statement on oath.
And March, since March.
Lord, we did all that we could, but
Mr. Onoja.
The matter is for cross-examination in spite of not filing defense.
Very well.
Yeah, so the witness is in court and he can enter the witness box. That was our agreement.
Invite him.
I beg, use your phone, I beg.
Simon Achenyo Joshua.
Yes, my lord, it's in the witness box.
Do you remember that on the 13th of December 22, you swore an oath to speak the truth? Can you hear me?
Yes, ma'am. Yes, my lord.
Do you still want to stand on that oath?
Answer now.
Paroma.
The Lord.
Do you still want to stand on the oath?
Yes, my lord.
Very well. So listen to questions that will be put to you.
Okay, my lord.
Can you give the registrar, can you give the witness exhibit S1, please?
Registrar, they are talking to you and you are doing another thing. Give
exhibit S1.
S1. Just like say exhibit S1. Speak, now say I'm with it. Just say I'm happy.
You have exhibit S1?
Answer nice.
Can you see the look at the
Yes,
exhibit with you? Okay, please go through the exhibit you have with you and tell me where your salary and allowances and other things are stated.
The document speaks for itself. That is no question.
That's exhibit what?
Exhibit S1, my lord.
Okay. Simeon, is there anywhere your salaries were mentioned in that exhibit? Talk to the court.
Hello, ma. Pardon?
Do they write your salary in what
Is
you are
there
having?
anywhere your salaries was mentioned in Exhibit S1 that you are holding?
Yes, my Lord. My Lord.
Okay.
So point to the particular paragraph where
yes,
your salaries and allowances, which you have referred to, where they are mentioned.
My Lord, the document speaks for itself. It's a document.
Mr. Lokoja, if you have an objection to the line of question, you do it properly.
Okay, my Lord,
My
Lord, sir, may I object to this line of question? Because
what
the
basis?
ground for this objection is that it's a document before court and the document speaks for itself. That is the position of the law. Document speaks for
About
itself.
the witness, Mr. Lokoja.
Yes.
Objection overruled. The witness has the document. Let him tell the court whether or not his salary is written there.
As the court pleases.
Tell the court, is your salary there? Tell the paragraph of that document.
The paragraph where your salary and your allowances are stated. You have stated that they are stated in this document. You have said yes. So tell the court where your own salary and allowances are stated in this document.
Do you understand the question?
Look at the document and answer to
Don't
court.
look at any witness. I mean, anybody. Look at the document that you are holding.
And answer the court. No, sit down.
Do you understand the question?
Look at the document. If they write your salary, say yes. If they don't write, you say no. Simple.
Yes.
If your salary rating there.
Mr. Onoja, please, can you allow me conduct proceedings?
This is not, it's not clear. See.
Witness. That is the document you tendered.
As the court pleases.
You have answered that your salary is written there. So point to the paragraph where it is written. If you cannot find it, tell the court you cannot find it. And if it's there, tell the court where it is.
My Lord, is there thing written there that says your salary?
Mr. Onoja,
it's like he has hearing aid. That's the problem. That's why I'm shouting at him.
Yeah. You can't be leading your witness. You can't be leading your witness. You can't interject. You should allow him to talk, except if he's not educated. And then he ought to have stated that in his testimony.
I only re-emphasize the same question to him in a louder
No, you
voice.
cannot. You cannot do that.
Witness,
I can't do that.
If you don't understand the question, you talk to the court. Mr. Onoja, I don't want to hear your voice anymore until after the conclusion of examination. Except if you have any objection to any process, then you can raise it formally and properly. So witness, tell the court where your salaries and allowances were written.
Yes, my Lord. The document with me is not clear. I can't find it.
Very well. Next question.
Yeah, you're just looking.
Now, Registrar, please, can you help me give him Exhibit S?
Collect Exhibit S1 and give him Exhibit S.
S, yes.
Court Registrar. Very well. Do you have Exhibit S, witness?
Yes, my Lord.
Do you have it? Yes.
Yes, my.
Counsel, go ahead and ask your question.
Now, look at there are two sets of documents in Exhibit S. The ones you are looking at now are the appointment letters. the appointment letters. There are 4 of them which you tendered.
Yeah. Yes.
Now look at the appointment letter of the 4th defendant, that is Atuluku N. Ocholi. Have you seen it?
Okay.
It's dated 26/2013. The appointment, the offer of appointment of Atuluku N. Ocholi.
I've seen it.
You have seen it. Very good.
Yes.
Now, look at that document. Is his salary and allowance stated therein? Is there any paragraph that talks about his salary and allowances?
Answer the court.
I'm coming, ma.
My lord. Don't stop talking to anybody. Look at the documents with you. You are the one to answer the question. It's a yes or no answer. If you can see it, say yes. If you cannot see it, say no. It is not there.
It's not here.
As the court pleases. Now, take a look at the same letter, but that's the one belonging to Yusuf Isaiah Idu, the 3rd defendant.
Okay. I've seen it.
You have seen it?
Isaiah Yusuf, huh?
Yes, Yusuf Isaiah Idu.
Yes.
Is there any reference to his salary or allowances in that document?
No. No.
Very good. So you can give the exhibits back to the registrar.
Last question.
Now, in your witness statement on oath, you said you were given a copy of exhibit S3. The registrar will show you exhibit S3. Is a document S3.
What is exhibit S3?
My lord, it's titled Omala Local Government Area, Abejukolo. Areas of salaries and allowances of immediate past political office holders from.
Okay, is that exhibit S3 court registrar? Court registrar.
Yes, my lord.
Is that exhibit S3?
Yes, my lord.
It's titled Omala Local Government Area, Abejukolo.
Yes, my lord.
Am I right? Very well. So look at it, give it to him. Also,
yes,
go ahead and ask the question.
Now, who gave you that document? Who gave you
Witness,
that
can you hear?
document?
Who gave you that document?
The treasurer to the local government.
The treasurer to the local government.
What is the name of that treasurer to the local government?
Long.
Yeah?
It's long.
What did you say? I can't hear.
It's long. I've forgotten his name.
You can't remember his name.
No, my lord.
Very well.
Now, did he hand this document over to you personally? Or how did you come about this document?
He gave it to us while we are in local government.
He gave it to you while?
Speak to the phone and speak loud, please.
Yes, my lord. He gave it to us, we political office holder then.
Okay.
Was it given to you with a letter or just the way it is?
He signed it and gave it to us.
He signed it and gave it to you.
We of office holder then.
So is that his signature there?
Yes, my lord.
Okay.
My lord, that is all for this witness, my lord.
Okay. Any re-examination? Mr. Onoja.
Yes, my lord. So he said he had showed his appointment letter. And
I cannot see you. I cannot see you. Any re-examination?
Yes, my lord, there's re-examination. I mean, I'm seeing you, my lord. My lord.
Mr. Onoja, the court needs to see you.
My lord, question was put across to him concerning his salary, whether his salary is stated on the appointment letter or not.
Yes.
So while you serve in the...
Go straight to the re-examination if there is
yes,
any.
that's the re-examination I'm putting to him. The local government from 2013 to 2016, where you paid salary. Simple.
The question
to him was whether his salary is stated on his appointment letter.
Yes.
And the answer is no. Yes. So clear the issue is while he was in the local government, based on Exhibit X Kriva, which says 2013 to 2016, where you paid salary at a single point.
Mr. Onoja.
Yes, my lord.
Mr. Onoja.
Yes, my lord.
The question was so clear, and the question has to do with his letter of employment.
Whether salary is stated on the...
Listen, whether his salary was stated on the letter of appointment.
Yes, my lord.
And he said no. So what is the ambiguity there? You are just raising the first question, whether or not he was paid.
The general public...
Was he appointed as a political officer for free?
I'm sorry, my lord. The general public rule, as well as the local government
service. You cannot open the question. You can't.
I'm not opening the question.
You can't.
The
because he produced, listen, Mr. Onoja, listen to the court. He tendered a document as his appointment letter.
Very
and in
much.
employment law,
Yes, my lord.
appointment letters should be able to state your salary or allowances.
Yes.
And he has stated that his letter of appointment didn't reflect his salary. So
Lord,
why are you now raising a different question?
Lord, sir, I have read through the general public rule and also read through the Kogi State public rule.
General public rule.
The general
Then
public
tell the
rule.
court in your final written address in the general public
Sorry, Lord,
rule.
there's an ambiguity in the question relating to the law. The ambiguity is, the law is that unpaid employment is prohibited. Hello, my lord.
Mr. Onoja, that is a matter of law.
It's matter of law. Even the question he asked, the cross-examination is matter of law. And that is why we have to clear it from here.
Okay, all of you can clear it there.
Yes, my lord.
Mr. Onoja, clear it in your final address. He will also have a right to rest.
It flows because the law says unpaid employment is prohibited. So whether you give an employment letter and you not write the salary there, the law has prohibited an unpaid employment. So what question is that?
Yeah, but that is not a point for re-examination.
Salary
that is not a point for re-examination. A re-examination is to clear any ambiguity. It is not to be addressing the court on whether there's unpaid employment or not. We will address that when we get to our final written address.
Why should you ask the question?
Mr. Onoja.
Yes, my lord.
Mr. Onoja.
Yes, my lord.
You're talking about the issue of law, right? Did I get you right?
Yeah, yes, my lord.
Very well.
And they said the labor
your final written address, you can tell me a whole lot about whatever you know about that law.
Ask all places.
And then your learned friend will now go ahead and also go through every law and tell them. So I'll request that you have no.
If the law prohibits an unpaid employment, you not even write the amount of pay. For that reason, we're not.
Is that all? Do you have any other witness?
No.
Do you have any?
No.
Is that the claimant case?
Yeah, that is the claimant's case.
CW, you are discharged. Claimant's case is closed.
There's a court cases.
Court registrar, give them a date for defense.
17th July.
I'll be here. No problem. It's okay.
It's convenient to the both of you.
17th July.
Yes, it's convenient, my lord.
My lord, is convenient for me. So Monday. July.
Case adjourned to 17/7/2023 for definite defense.
All
the next case.
Case number 7, NICN LKJ 01-2023 between Idigbe Emmanuel and 8 others, and Kogi State University Ayimba and 3 others. Parties are absent.
Appearances.
May it please my noble lord. I am F.A. Ademu. My appearance is for the claimants.
Is it Adamu or Ademu?
Ademu, F.A. Ademu, my lord.
Okay. For the claimant.
For the claimant. My learned friend.
Any other appearance?
My lord, my learned friend, Hesho Hassan, appears with me. Thank you, my lord.
Any other appearance? Any other appearance?
Yes, my lord. Yes, my lord. With humility to noble court, OU or Malice, my name. OU Malice, my name.
For
the first defendant applicant.
For the first, only first.
Holding a brief of H.O. Smiler.
The brief of H.O. who?
H.O. Ismaila Esquire.
Very well.
Yeah.
Any other appearance? Any appearance for the second, third, and fourth?
May the court be pleased, sir? Idigbe Mejabi.
What are the initials?
E.A. Mejabi.
Okay.
My lord, I'm here with G.O. Salifu.
Is this Salifu or Salihu?
Salifu. Salifu.
Salifu, F.
F.
You are for who?
A. Abu Bakar, the second to defendant.
For the second to
fourth.
Very well. Defendants, have you all filed your defense to this suit?
My lord, I have a motion.
Your reaction to the originating summons, have you filed any?
My lord.
The first defendant, you have an application.
I have an application, a motion or notice.
Yes.
To appear out of
Do
time.
what?
Memorandum of appearance. Extension of time, sir, for me to file my memo of appearance out of time.
So when do you want to file the defense?
I will do that as soon as this thing is granted. At least 7 days will be sufficient for 15 days.
Mr.
Counter. Counter.
Mr. O'Malley. So you are waiting till your memo of appearance is regularized before you file your defense?
Yes.
Is that what you are telling the court? Is that the practice in your jurisdiction? You wait till your memo of appearance is regularized.
I'm supposed to have accompanied my counter, but the person I'm holding brief of. I'm just holding brief. So next time, sir, shall be guarded against. If not, ordinarily, our memo is supposed to accompany our counter affidavit and everything.
I give you 48 hours to file.
As the court please.
Order is as prayed.
As the court please.
Okay, sir. As court please. So it started.
Mr. Mejabi.
Yes, my lord.
When do you intend to file your own reaction?
My lord, sir, will be.
When do you want to file your counter or whatever you have to file?
We shall seek the court to file within 7 days, my lord, sir. In that we have just been briefed to defend the suit. We are very sorry for the inconveniences caused to court and to the claimant.
Defendants are to file their response to the originating process within 7 days. Advance copies to the claimant, who is at liberty to react to same.
As a court. So most grateful.
Registrar for hearing.
Date for hearing.
What date?
17th July, my lord.
Is it convenient?
Very well, my lord, sir.
17th
July is convenient. It's convenient to the claimant.
By agreement of counsel, case adjourned to 17/7/2023 for definite hearing.
As God.
Call the next case.
For the indulgence.
That's all for today, my lord.
Very well. All right.
Our counter.
Fish. M.O. Hassan, sorry. M.O. Hassan.